Here.
Commissioner Garcia?
Here.
Commissioner Lukes?
Here.
Commissioner Perez?
Here.
Okay, thank you.
Pledge of Allegiance. It's a pleasure to have you back, Mr. Lukes.
It's a pleasure to be back.
I'm glad you resigned your resignation.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let's see, do we have any changes to the agenda from staff?
Mr. Chairman, I do have one change under item 6 under matters from staff.
Okay.
What I would like to include in there is a discussion on commissioner training.
Okay.
So I would just like to add that under matters from staff. So I guess you can call that 6B, even though it's not labeled, we can consider 6A the resolution 13-02, and then 6B would be training for commissioners.
Okay.
One other item I'd like to add to, I can also only for presentation purposes, not discussion or decision, I'd like to just brief you on the talks we've been having with the county about a joint town-county planner position.
So let's make it
So make
6C.
that joint planner. So we've amended the agenda to add items 6A, B, and C. Any other changes from the commissioners?
I just had one question on under 5B.
Okay.
Just that last sentence, it says for us discussion, and it says consideration of the town council meeting to be held on March 26th. Well, is that a typo? Is it March or April? Or, I mean, that's gone and passed for April.
I saw the same thing.
Mr. Chairman, Commissioner Garcia, it's my understanding that the sign code ordinance is currently in the town attorney's office, and he's reviewing it he needs to make some revisions to that sign code. So at this point, the sign code,
Do we just want to remove that from the agenda or not?
Or just that last sentence and just put their discussion of proposed changes to the town
Yes,
house.
I think that would be good, yeah. That would be a good change, because, Mr. Foster was the one who created this agenda, but, that would be good if we could just take out those last few words, where it says proposed changes, anything after proposed changes to the draft of the sign code. I think, and then end it there, and then strike out the rest, because, again, Mr. Chairman and Commissioners, this item was tabled at the town council meeting, and it is now in the town attorney's office awaiting his review and revisions before we will present it to you again.
So already, that's scheduled as a final public hearing, right?
Yes.
So it's something we have to take action on. Is that something we continue to table? Do we?
Well, it just says for
deny it?
discussion on the agenda, so I don't.
But it is a final public hearing, which means that we either approve, deny, or continue.
Well, Mr. Chairman, at this point, I would recommend keeping it on the agenda because, as you stated, it's under final public hearings.
Okay.
And the reason we kept it on there also was that so we can get input from you, so that we can forward to the town attorney on any revisions you think that might, could be incorporated into the sign code while, the town attorney is looking at that. So at this point, I would recommend keeping it on there and then, reviewing it. And then when it is brought to you the next time, I think the best course of action, and the town attorney can concur with me on this or not, but I think the best course of action would be is we would re-advertise this as a final public hearing in the newspaper, because I'm not sure how long it's going to take the town attorney's office to finish, revising the proposed sign code. So it would be re-advertised as another final public hearing, before it was brought to you again.
Great.
That way, there would be some continuity,
Okay. Thank you, Rudy.
You're welcome.
Okay. Any other changes from the commissioners?
I had one comment.
Okay.
Since Manager Rodriguez brought it up anyway about the potential joint planning commission.
Is it in regards to its placement on the agenda, or is it a question
Well,
in
it's a
regards
matter.
to the...
It's a matter from the commissioners. Didn't you ask for a matter from the commission? Number 7?
Yeah, should we add it under there?
Well, I don't know.
Uh-huh.
I'm going to bring it up, and then maybe we can decide where it would go. I'd like to know about what's going on as far as staff, at the staff level, for the planning department here in our department that we technically oversee, or work with. I'd like to know what kind of plans the town has as far as rehiring, et cetera, et cetera. So.
Yeah, I'll include that in my remarks.
Okay, so we'll add that as, right now we'll add that as 7A.
Well, we can bring up anything under.
Staffing,
under number
planning, and
7,
zoning.
Number
Right.
7. So we're
We
not
may.
limited.
Just wanted to put that.
I'll put it in there. Let's put it in there as 7A. Okay? So let's see. So we have the agenda, and we're going to amend item 5B to include only discussion of the proposed changes to the Town of Taos sign code.
Yes.
We're going to add 6A, consideration of Resolution 13-02. 6B is training of commissioners.
Yes.
6C is the joint powers agreement with the county regarding planning and zoning. And we'll add 7A, which is a forecast of staffing and a plan for planning and zoning.
Mr. Chairman, I'd like to add 7B, and the subject will be election of officers of P&Z.
Election of officers is 7B. The agenda has been amended. Do I have a motion
So move.
and a second?
I'll second.
All in favor, say aye.
Aye.
Okay. Approval of meeting minutes, and we have no minutes for the race. We have the February 6th minutes. I see. February 6th, 2013. Are there any changes or amendments to the meeting minutes from February 6th, 2013?
Mr. Chairman, under roll call, absent Pavel Lukish, Vice Chairman, but also Commissioner Garcia, I believe, was absent because he's not
That's
listed
correct.
above.
Okay.
Any other changes? If none, a motion to approve the minutes as amended,
So move.
and a second.
Second.
All in favor, say aye.
Aye.
I will abstain since I wasn't here for this meeting, so.
Okay. Taken, note taken. Let's see, Rudy, I think with that we can move on to final public hearings. Do you want to go ahead and give us the rules for final public hearings?
Okay, thank you, Mr. Chairman. Rules for final public hearings. In order to conduct an orderly and impartial public hearing, the chairman will preside and make rulings for testimony given at tonight's meeting. The Planning Commission members have received and reviewed extensive materials regarding each application before the Commission tonight, including the application and all related documentation, staff reports, and any letters in the file either supporting or opposing the application. The following rules will apply. Number 1, all persons wishing to speak must first sign the speaker list and will be called in this order. Number 2, speakers will be allowed 3 minutes to address the Commission. Number 3, speakers representing other persons will be allowed 5 minutes. The speakers must show written documentation that they represent someone else. Number 4, the chairman will allow cross-examination or rebuttal if the chairman feels this is pertinent to the findings presented. Number 5, the chairman will not tolerate shouting or unruly conduct and may direct staff to have any person removed from the meeting for cause. Number 6, the chairman will then close the public hearing and allow the commission to deliberate the pending action to be taken based on findings presented by staff and by the public. The commission may approve, deny, approve with conditions, or postpone the decision to a subsequent meeting announced by the commission. Number 7, the chairman will then call for the question and voting will take place as to how to proceed on the application. Number 8, anyone aggrieved by the action of the zoning commission may file an appeal pursuant to the appeals procedure set forth in the Town of Taos Land Use Development Code. The appeal must be filed within 10 working days of the decision. And number 9, all cases will be heard on their own merits and do not create a precedent for other applicants.
Thank you, Rudy.
Thank you, Mr. Chairman.
Let's move on to agenda item number 5, final public hearing, discussion and recommendations of the proposed changes to the Town of Taos Land Use Development Code.
Okay, thank you, Mr. Chairman. At this point, what staff is recommending is denial of the proposed changes to the Land Use Development Code, to consider the recommendations of the planning consultant to be hired to assist the planning department in streamlining the LUDC and other procedures administered by the department. So, Mr. Chairman and Commissioners, staff is recommending basically that this be denied. And then again, as is the case with the sign code, what we will do is once we receive the feedback and from the planning consultants that we've hired for our department, and once we get their proposed revisions into the LUDC and finalize, then what we will do again is we will re-advertise this hearing as a public hearing, and of course it'll be put in the newspaper and on our website and things of that nature, and it will be sent out to all the media via email when the time will be, when this will be heard again.
Understood.
So at this time, Mr. Chairman, I'm not sure what the time frame is going to be for that, but I will keep you informed, you and the commission informed as to when that will be happening.
Okay.
And of course, you'll be getting packets and the regular things that you always get.
Okay.
When we're ready to present it to you again.
This is a final hearing. Is anybody signed up to speak on this issue?
Let me see, Mr. Chairman.
And then after that, I think we can just take any questions from the commissioners on revisions to the land use code.
Mr. Chairman, nobody has signed up to speak on this issue.
Okay. So with that, I think we'll close the public hearing, and we can have any questions or considerations from the commission. If there are none.
I've got one question.
Okay.
Who's the planning consultant to be hired?
They're a firm out of Albuquerque. They're architectural research consultants, and they have a wide range of expertise. They have on their staff a former city manager, I believe, with the city of Farmington, and they have a planner from the Santa Fe. He's got extensive experience doing master plans, and he has worked for the city of Santa Fe for many years. And so there's an extensive range of experience from these consultants. They have many years in state government. A lot of them have many years developing master plans and developing codes for communities. So the people we'll be using to help us with these revisions have a lot of experience and knowledge in this area. So,
Commissioner Garcia?
Yeah, I just have one question, just so I understand. Are we making a decision to turn this down, or are we just tabling this until the consultants come on board and present something else?
I would say there was a draft of these revisions which was put in front of us to pass.
Right.
So I think at this time we're denying that draft until it comes back in a different form.
So will we start the process again and go through advertising and having discussions with the public and have a final hearing when that happens?
I believe so, yes.
okay. Actually, Mr. Chairman and Commissioner Garcia, it will actually go through two hearings again. It'll be a preliminary public hearing and a final public hearing, so that way we can get as much input from the public as possible, because we're going to be coming up with a brand new set of revisions. So it'll have to start from square one again, basically, as far as public hearings goes.
Okay, so we're declining that. Okay.
Yeah, so I would recommend that.
Commissioner Perez, did you have a question? No? Commissioner Lukes?
Is it because the staff was not happy with the revisions to the LUDC? What prompted this staff to hire some outside consultant?
Mr. Chairman, Commissioner Lukes, well, there was quite a few changes that were proposed by Mr. Morris, our former planning director, and unfortunately, Mr. Morris didn't consult staff, on a lot of the changes that he was proposing. And so there was quite a few things that staff had questions and concerns about, staff being Mr. Foster and myself. But as you know, Mr. Foster is no longer with us, so, but I had quite a few questions that, Mr. Morris wasn't able to address before he resigned. So there was quite a few issues there that occurred that, we were not able to address with Mr. Morris before he left.
Yeah, I just hate to see this never-ending process, and part of which is the streamlining, which I think the sooner that is implemented, the better. And
Yes.
do we have a timeline for this, for hiring somebody? And how much time do we give them to come up with their proposed changes? What is the timeline?
Mr. Chairman, my acting director can answer that question for you.
Mr.
Good evening.
Rodriguez, thank you. Yeah.
Howdy. Mr. Chairman, Commissioners, I can answer those questions. It's because, first of all, we want to take a more thorough look at the processes, the procedures, even the platforms that we make available to, for processing requests and all of the activity that this body and this piece of legislation governs. Everything from streamlining as well as possibly putting a lot of these processes online so that people can serve themselves on a self-serve basis. So what this consultant is going to do is going to look at this work, but is also going to look at our procedures and our, the process that we use, and also to see how much of that we can put online. Now, at the same time, and I'll be talking about this later on in my presentation about what we're thinking with the county. The county wants to go through some of this process as well, and so they are considering being part of or also retaining the same consultant so that we can look at both our processes. So there would be some continuity. There would be some ensemble between the logic and how we do all these different sorts of things. So to answer your question real quickly, it started out to be a much narrower pursuit and has now broadened to include even the restructuring how we do business at the planning department. That's why we're holding
So
it
do
back.
we have any idea, time-wise? 6 months?
No. It won't. No, it won't be 6 months. But this will be, in all likelihood, something you'll be looking at over the course of the summer. At this point, I don't have dates for you because, well, again, I'll mention in my remarks, we are just now putting the team together, including Mr. Bellas, and I'd like to work with him to come up with a timeline for that. Because again, the county, the town and the county will be going together on this.
Yeah, I mean, I like the idea and combining with the county. I'm just concerned about.
Yeah, it takes too long. I understand it could take long, and I commit we will come to you. We're working with you very closely, beginning with the presentation of a work plan. What all is going to get touched, when that will happen, when it will be coming to you, and when you can expect a final decision.
Right. Thank you.
Any other questions from the commissioners? If not, I think we can entertain a motion to approve, deny, or continue.
Approve the denial.
Approve. We can make a motion to approve, a motion to deny, or a motion to continue the land use development code revisions as presented.
I think we need a lawyer to formulate this motion.
Well, I'll just go after this and make a recommendation with the staff recommendation to deny the proposed changes to the land use development code at this time.
We have a motion. Do we have a second?
Second.
Roll call vote. Mr. Pereira?
Okay, thank you, Mr. Chairman. Chairman Patterson,
Yes.
Vice Chairman Lee,
Yes.
Commissioner Lukes,
Yes.
Commissioner Garcia,
Yes.
Commissioner Perez.
Yes.
Okay, thank you.
With that, I think we can move on to agenda item number 5B, discussion of the proposed changes to the Town of Taos sign code. Do we want to cover some of the covers the sign code as is, or do we want to? How does staff want to proceed?
Mr. Chairman, I guess because this is the final public hearing, what I would recommend is, of course, that we follow the usual route, which is, if you have questions for me, I'd be more than happy to answer them. And then once you have, answer your questions, then you can open it up for public hearing and then close the hearing, and then we can work from there. But really, at this point, what I would ask of the commission is that if you have any recommendations on what your thoughts would be on some of the changes that you would like to see in the Town of Taos sign code at this point, also as part of this public hearing, I would like to get your feedback on that as well.
Who's taking the lead on the revisions to the sign code this time? Is this something that you're working on, Rudy, or is it?
It's my understanding from Mr. Foster before he left that he had turned it over to the town attorney's office, and he is currently working on that. Is that correct, Mr. James?
Well, currently I'm sitting here, but yeah, I am going to be working on it, yes.
Oh, okay. All right. Thank you.
But by default, it ended up in my office. We also, I should explain some of this. So, the original concept here was premised on the planning department receiving, excuse me, some sort of authorization from the Department of Transportation to affect changes in the right-of-way that it's owned by the state. Actually, there's a letter sitting on my desk from March of 2012, where the Department of Transportation promises to expeditiously do this. And as it turns out, they're not only not going to expeditiously do it, they're not going to do it at all. So the concepts that at that time Mr. Morris was the planning director was pursuing in the sign code are no longer possible. So it's essentially causing a fairly substantial rewrite, and then having received input at the last council meeting relative to the council not seemingly wishing to make major changes in the area of commercial signs, that caused another series of rewrites. And depending on what you guys tell me tonight, it'll probably cause a third series. But at any rate, hopefully after tonight's meeting, we'll have enough direction to bring back a sign code that probably will not have as many amendments as you originally anticipated, given the changes in anticipation from the Highway Department. And a couple of the things that my office could really use some input on are, in specifics, are the issue of monopole signs with fabric and where those should be allowed, or if they should be allowed. And that was a big sticking point. I'm not certain where the council came down on that. I guess they finally decided that those would be acceptable. So we could use some input on that. Other than that, I think I'll just be more of a listener, but I could use some input from this commission on the issue of those fabric signs that are on single poles.
I would say honestly that it seems like the sign code's been kicked around so much that I can't really say I understand where it stands in terms of where we are now and where we're heading. It seems like I've seen it 3 or 4 times. Some of them have been kind of redlined and marked up and inserted, and I guess this is what we have in front of us tonight. Appears to be a pretty complete draft, but I'm not sure what the differences are from the ordinance that we have. So I'm not sure I feel prepared to really make any recommendations.
And I'll make a comment.
On the draft
None of your potential changes are in here from your discussions with the state. Is that right?
No, they couldn't possibly be, because I haven't begun the redrafting yet. I think what you're looking at is the last iteration that was left here by Mr. Morris, and it may have some changes that were proposed by Mr. Foster. It does not have my changes in it.
So I have one more follow-up question. If we are going forward with, potentially reviewing the sign code ordinance, is it going to be you, Mr. James, that's going to be kind of the lead, the point man for the sign code, so we don't have 4 or 5 different people that are chiming in on it? I know it's not your fault. I mean, but Mr. Morris left, and Mr. Perea is doing the best he can. It seems like it is in your court now, but maybe it's not in the future. Maybe it's back in Mr. Perea's court, or maybe Mr. Rodriguez is taking it over at that time.
No,
are we going to have one person that we're working with it?
That person will be me, and my direction from the council is to try to get this before them. I think it was the second meeting in April, but I don't know how that's going to work, because we're going to have to bring this through this commission first, and we're not going to have a meeting here before the second meeting in April. But at any rate, it will be me that will be doing it. I've committed to doing it. I'm going to finish this thing. I'm going to basically take it back to where it started originally, redline the changes. I don't think they're going to be as substantial as the changes you've seen, and we intend to get this done in the next 4 to 6 weeks. And I more than understand and share the frustration of having reviewed I don't know how many iterations of this, but we're going to reel this in and get it done.
Mr. Chairman?
Commissioner Lukes?
I agree with the chairman. I too kind of lost track where we are with that. But to answer your specific questions about the signs on one pole, I think they should be relegated to football games. In other words, I don't like the monopole signs. I don't know how the rest of the commissioner feels about it, but we discussed it at the Historical Preservation Commission, and they felt the same way.
Rudy, on before, if a business opened, a new business opened, they could put up a temporary sign for X amount of days, and then that sign was supposed to come down. Is that not correct?
Yes, in the current draft of the sign code ordinance, Chairman Patterson, Commissioner Perez, it does allow for temporary signage still under this current draft of the ordinance that you see here. They're allowed to put a temporary sign up, and then they'll have to take it down and wait for 30 days before they can put up another sign, another temporary sign.
Right,
so
because these single pole, they're putting them up on a new business opening to attract people, and then they just tend to stay there over the life of the business.
Yeah, because under the current draft, they're allowed to display a temporary sign for 90 days, and then they have to take it down, and then they have to wait 30 days before they can reapply for, another 90 days. So
because, according to the wording in here, those signs are not permitted. They're not they are advertisement, but they aren't, they're more than the allowed
That's
square footage of what they're allowed.
Yes,
and they're staying up, and I think they're not.
yeah.
They shouldn't be.
Yeah, that would be a code enforcement issue, Commissioner Perez, but you are correct that under this draft of the sign code, the temporary signs are not counted towards their 3 allowed permanent signs, for businesses. So.
But these single pole signs tend to become permanent.
Well, see, yeah, that's correct, yeah.
Yeah, I couldn't even remember where there is one that's been there forever.
Okay.
To bring this all back, I don't understand. It's a final hearing for us to make a decision on something that we still are confused about and what the changes are going to be. So my opinion is that we deny it and let them go through the process again. I know we don't want to hear that, but I mean, how can we make a decision, yay or no, or on something that we're confused on those changes and what those proposed new changes might be through the attorney's office that might take place? I mean, there's just no way. I think you need to go through the process again. It'll probably be quicker because they've addressed some of the areas, and unless those are going to be changed again, they can put a document together for us to review, but I don't see how we can make any kind of decision except to deny it. That's my opinion.
Understood. Let's see. Anybody signed up to speak on this matter?
Yes, Mr. Chairman, Mr. Jeff Northrup has signed to speak up.
Mr. Northrup, welcome to our meeting.
Thank you very much.
Yeah.
It's a pleasure to be here.
Please state your name.
My name is Jeff Northrup, and I'll probably speak for 5 or 6 minutes, if that's okay.
Do you swear to tell the truth?
Yes, I do.
Okay. Let's set it for 5 minutes.
Okay.
1, 2, 3, go.
Okay. I don't see what the New Mexico Department of Transportation should be involved in the signs in Taos. Most of their rules are based on 200 feet from one side of the road to the other, or 60 feet from one side of the road to the other. The map you're dealing with, one of them was generated in, I think, about 2007. The other one was generated in 1977. Mr. James addressed the fact that New Mexico Department of Transportation promised to give him or the town of Taos some sort of information. I don't even know why we need to mess with them. If it's a matter of safety, we could best determine what's safe and what isn't in the town of Taos. And if the New Mexico Department of Transportation challenges us, then we can deal with it at that time. But their restrictions don't seem to make any sense, and why should we bother following them? In their codes, they talk about culverts and utility lines and buried utility lines and overhead utility lines, and it's just all a bunch of nonsense related to signage, as far as I could tell. And that 200-foot thing comes from, as I said, 1977, and until we get a clarification on what that means, you can't possibly rewrite the sign code, because with the street being as much as 80 feet wide and as little as 45 or 50 feet wide on the south side of town, half the buildings, or a number of the buildings, would probably be in the right-of-way or right up next to the right-of-way. We don't know what the right-of-way means. Does it mean anything? How is it related to safety? And that's presumably what all this is driven to. There might be some aesthetic concerns, but Taos is not a town that's generally much concerned with aesthetics, which is just the way I like it, and I think many other people do too. We don't want to look like Santa Fe or Scottsdale, Arizona. We want to look like Taos the way it has looked, traditional, kind of funky, and it's putting pearls on a pig if you start getting very restrictive on the sign code and let other things go by the boards. And again, back to that utility thing, the state seems to be tied into the utility lines, and I just don't see how that can possibly be related to safety and signage. And is there any proof that signs near the road are more dangerous than signs away from the road? If signs are near the road, then they're easier to read. If they're off the road, they're more difficult to read, and which would challenge the public safety. That's why one reason I like my signs, and that's the reason I think I haven't had any wrecks. Not that there won't be someday, but there haven't been any wrecks when I was picketing, because the signs are right up on the road. You can watch the roadway and read the signs at the same time, basically. And all this talk about safety, and yet do you realize the speed limit going past Walmart in both directions is 40 miles an hour? It's an unrealistic speed limit, and yet that never comes up, and that's a decision that's made by the state. That's the kind of thing we might think about challenging rather than signage. And even at 35 miles an hour past, almost into the town, I think it's down to Rancho's Bouterie before it drops down to 30 miles an hour. The speed limits are just unrealistic, especially when you have that turning lane. And government should be here to promote businesses, not to hinder business. And when you start pushing people's signs away from the road, I think you do hurt business. And when you start having restrictions that don't need to be there, you're hurting businesses, and not to mention you're hurting the right of people to picket and use their rights of free speech. And governments should be here to promote the rights of free speech, not to hinder them, not to hide their errors. And often that's what it seems like they're looking to do. That's the reason we're dealing with the side code now, because the town didn't like what I was doing, and so they're making a great big deal out of trying to rewrite the sign code.
I think you have about 1 minute left, Mr. Northrup.
Okay, I have something I've written out. I believe we've had a shoot from the hip, disorganized, directionless rewriting of the sign code since last November, including the ridiculous suggestion of a safety zone, which is gone, at least for the time being. We have people who know nothing of public safety as it relates to signage. We have people who are primarily interested in stifling the First Amendment to the United States Constitution, not supporting and promoting it. Those are the people who are looking to write the sign code. Basically, the administration of this town might just as well be choreographing the Bolshoi Ballet as writing a sign code. They don't know what they're doing. Any questions?
Jeff, Mr. Turp, I believe your 5 minutes is up.
Just in
Commissioner Lukes.
In conjunction with what Mr. Northrup said, the rationale for talking to the Highway Department is?
It's pretty straightforward, Commissioner. The rationale is that the case law in New Mexico is explicit that the state of New Mexico owns the highway and the highway rights-of-way. case law and the statutes in New Mexico are explicit that the New Mexico Department of Transportation has exclusive jurisdiction over what happens in that right-of-way.
My understanding was that there was no signage allowed in, at least my experience when I put real estate signs in the right-of-way. It was inevitable, before I learned my lesson, that I would get a call from the highway department to take it right out. There were no signs allowed in the, other than traffic signs.
Oh, that's absolutely correct. That's also in the administrative code. There is a complete ban on signage of any sort in the right-of-way, and those signs are deemed to be removable with or without notice to anyone.
Right.
So that's explicit, and that's why we're dealing with it.
Yeah, that actually happened for our annual car show. We put those little signs that say car show at Kit Carson Park, and they were all removed by the highway department this last year.
No, that's what they do.
Well, my question is, why do we allow them to do that? We don't need the highway department telling us how to do the signage in our own town.
They own the highway.
They may own the roadway, but they may have control over off the roadway on the other side of the curb. But do they need to have that control? I mean, the businessmen own that property, but the highway department exerts its control over that property as it relates to signage and other things. But is that necessary? We don't need them to tell us what to do with our own signage.
It's for public safety.
Well, I don't know whether it is or not. Who's to say that it is or not? As I suggested before, signs closer to the road might be safer than signs away from the road. Who knows?
According to this commission, we're going to defer to the town attorney as to what applies and what we have jurisdiction over and what we don't.
Okay,
That's not an item for us to interpret or make a decision on. It's
and
an item for us to be.
I'm sorry.
Yeah.
Nor would you suggest challenging the highway department on their restrictions on our signage in our town?
I don't have an answer to that.
Okay.
Rudy, is there anyone else signed up to speak on this issue?
No, Mr. Chairman, there is not.
Okay. With that, I think we'll close the public hearing. And any discussion from commissioners?
I have just a point of confusion a little bit. If the highway department has exclusive jurisdiction over signage in the state highway right-of-way, then why are we attempting to regulate it? If it's already regulated by the state, then why are we even touching it?
Well, we're not. It's sort of the whole point of getting rid of the ill-fated safety zone concept or any other potential additions or restrictions or rules or regs. I mean, they're just not enforceable. So I think that the planning department was anticipating that they would get some sort of permission to do something, and we're operating along those lines for months, literally. And then it has now become very apparent that that is not going to happen. So we're stuck with the right-of-way, the preclusion of any signs in the right-of-way. We don't have the ability to make rules that are enforceable within that right-of-way. So one of the major revisions to this sign code will be making sure that we don't impinge upon that.
Okay, thank you.
Anything else from commissioners? With that, we would entertain a motion in regards to agenda item 5B.
I make a motion to deny this final hearing on the sign change and wait till we get a final draft from the legal department.
Second.
We have a motion and a second. Any further discussion? Mr. Perea, can we have a roll call vote?
Okay, thank you, Mr. Chairman. Chairman Patterson?
Yes.
Vice Chairman Lee?
Yes.
Commissioner Lukes?
Yes.
Commissioner Garcia?
Yes.
Commissioner Perez?
Yes.
With that, I believe the public hearing portion of our agenda is closed, and we can move on to matters from staff. Item number 6A is Resolution 13-02, a resolution of the Town of Taos Planning and Zoning Commission to support the Town Council in establishing a policy not to consider any request for annexation until a development plan for the new annexed State Route 64 to the Taos Regional Airport corridor has been adopted. Mr. Perea or Mr. Rodriguez presenting this ordinance?
Okay, Mr. Chairman? Okay. Yes, basically, Mr. Chairman, what I'll do is I'll read the resolution into the record for the benefit of the public, and then I will have a brief discussion on it. And basically, I'll go ahead and do that now. It says, a resolution of the Town of Taos Planning and Zoning Commission to support the Town Council in establishing a policy not to consider any request for annexation until a development plan for the newly annexed State Route 64 to Taos Regional Airport corridor has been adopted. Whereas the Town of Taos has recently annexed State Route 64 between the town municipal boundary and the Taos Regional Airport for the purposes of bringing the airport into the corporate limits, and whereas this annexation of the state highway right-of-way may lead to additional requests for annexation into the town from private property owners contiguous to the annexed right-of-way, and whereas the town currently has no binding zoning or land use regulations in place for these unincorporated areas, and whereas Taos County has been meeting with neighborhood associations, businesses, ranchers, property owners, and their families for more than 3 years to develop neighborhood zoning for each parcel based upon the consensus of the owners and is near the adoption of that zoning, and whereas some of these unincorporated neighborhoods may already have county zoning in place that has been working successfully to 3 to 5 years, and whereas as it could be in the best interest of affected property owners, the town and county, for there to be a well-developed review and acceptance procedure for private property owners seeking future annexation, as well as for there to be accompanying zoning that is consistent with the business plans and wishes of the neighborhoods and property owners impacted, and whereas it is the desire of all parties to avoid land use and development uncertainty that might adversely impact investment along the proposed annexation corridor, which corridor presents all commercial and industrial growth within the unincorporated portion of the county since 2010, except for one business. Now, therefore, be it resolved that the Planning and Zoning Commission support the Town Council in establishing a policy for allowing for an orderly consideration of annexation petitions along the newly annexed corridor to the Taos Regional Airport. And then there's 4 different items under this where it talks about the first item, the town will not approve any petitions for annexation by private property owners contiguous to the State Route 64 right-of-way and Taos Regional Airport until 1 year from the date of this resolution or when the town and county approve a development plan for this corridor, whichever comes first. And number 2, the town will work with the county in instituting the neighborhood zoning adjacent to these annexed properties and corridors that the county, neighborhood associations, and property owners have agreed upon. And number 3, the town will work with the county toward development of a joint partnership agreement to allow cooperative land use planning, permitting, zoning, building and fire codes, and infrastructure improvement or development, including roads and utilities that will ensure seamless development in unincorporated areas or neighborhoods of the county adjacent to the municipal boundaries and that may at some point be incorporated into the town. And finally, number 4, the town will work with the county in developing an orderly procedure for the review and acceptance of applications by private property owners and businesses for annexation that will ensure public health and safety, orderly growth, a vibrant local economy, neighborhood compatibility, and not place an unreasonable burden on the existing infrastructure, town services, the county, or the town's current taxpayers. And then, Mr. Chairman, it just goes on to say, passed, approved, and adopted this 3rd day of April 2013 at the regular meeting of the Town of Taos Planning and Zoning Commission. So, Mr. Chairman, this is the latest version of that resolution that I delivered to you this morning. So this is the one we will be working with and not the one that you originally got in your packets. And I stand for any questions at this time.
Mr. Chairman? I do have one question.
Commissioner Garcia.
The resolution itself, I do support the annexation and so forth, but on item 1, this commission, we've been working on the 2020 vision and trying to make sure we put something in place and follow it. Why would we indicate here until 1 year from the date of the resolution or when the town and county approve a development plan? Why would we put the 1 year from the date of the resolution? What happens if there's not a a development plan in place, are we going to open it up after a year to allow anybody to submit annexation? I'm just trying to...
Yeah, quick answer to that is yes. Under state law, citizens who have property contiguous to town limits have the right to petition the town for annexation. And so really, even at this point, if they want to come forward, we have to give them due consideration even now. What we're trying to tell them here is that if you come now, we will not look very favorably at those petitions until we have a plan in place, or no more than a year from now. So what we're hoping to do is communicate to private property owners out there who are considering petitioning the town for annexation to hold off until that plan is in place, and those inquiries are starting to come in informally, at least at this stage. So really pushing it to a year is about as far as we think we can go. I know it makes our town attorney a little nervous that we would push it off any period of time. But what we're trying to do here is work with the county. The county asked us to build on the work that they and the substantial investment of time and effort they made to try and come up with a plan for the 64 corridor. Now, this is not the El Prado part of that, but just the part from the blinking lights going to the airport. And so what they're asking us to do is to build on that and not just pour it out with annexation, knowing that in all likelihood there will be petitions for annexation. And so their fear is that if we start getting them, that people will then ask for petition for annexation outside of that plan, or in other words, in order to get away from that plan. And so we're working on this happily.
Saying that, and I do understand that, but this resolution is coming from the Planning and Zoning Commission, and I'm only one member, and I do support this. But why can't we change the language and say that, even though the council is still going to make that decision, mm-hmm. and you're indicating the public has the right to ask mm-hmm. for annexation, and you would have to deal with that. But this is just a resolution saying that we do support this. Mm-hmm. But my preference is that since we're working on the 2020 vision, and we don't want an array of annexation coming out and different things happening, this Planning and Zoning Commission feels that we should control that. And do we have any right or strength in that aspect? No, but it's a resolution. That's all it is, that we support the annexation. But I feel more comfortable removing that 1 year from date. I'm just making that as a comment.
Is the 1 year just kind of a good faith to the county saying,
yeah.
Yes. We're not going to try and take all?
Yes, sir. We promise at least for 1 year to give you a shot to make that as a plan, and that way when annexations come in, what you'll be seeing, and by the way, we'll be working very, very closely with you. You'll be seeing those drafts. You'll be seeing those presentations, the presentation of that plan. The idea is that when people come in to get annexed, they will know that at least our intent will be to annex them with the zoning according to that plan, more or less. Which, by the way, you will be brought to you here, and you will accept it, or you will be asked to vote on it.
Am I to understand that the council are already annexed?
Yes, sir. That annexation was effected March the 12th.
Isn't that in conflict with our own code to annex without zoning?
No, because you can't zone until you annex, and so you annex soon thereafter.
I was under the impression that it goes hand in hand.
Well, it goes hand in hand, but it's not simultaneous, no.
So how much time passes from the annexation before the newly annexed area is zoned? So right now it's annexed, but not governed by any kind of land use code. What is it? No man's land?
No, what it is right now is non-conforming pre-existing use. And so whenever you annex any place, whatever people are doing at that time, people have some rights to maintain that, and you can't sort of annex them and then sort of zone out that activity. So right now, the only thing that's it's subject to that discussion at this point is the airport. And right now, we've been using it as an airport. It is a continuing use pre-existing our annexation, and so it has standing as far as that goes. Now, we're working through the process, a rezoning or a zoning for the airport that includes the...
I'm more talking about the El Prado area.
Oh, no, we're not annexing El Prado, we're just annexing the right-of-way.
Okay, just the right-of-way.
Yes.
Just the road,
And then
yes.
to the airport.
Yes, just the state-owned right-of-way,
Okay.
no other properties.
Thanks
And so
for the clarification.
So what this resolution contemplates or anticipates that people along the right-of-way are going to come to the town and say, please annex me too.
Because I'm contiguous to the...
Because I'm contiguous now, and all we're saying is, we're telling everybody, we're going to wait for a year or until we get a plan in place. The county says that they have a plan already in place. That plan will be brought to you. We'll ask you to weigh in on it, and then it'll be approved. And that way, once it is approved, that will be the part of and parcel of the procedure that people will be going through when they ask for annexation. So, for example, if they are in a zone that is thought to be commercial, when they come in, the recommendation, at least from the staff, will always be to annex them and zone them subsequently with the zoning that matches that plan.
It seems like that the airport would command a completely new zoning designation that doesn't exist on our
To
books
begin
yet.
with, yes.
Yeah.
Yes.
Okay, thank you.
Commissioner Lukes, if I may, I'd like to go back to the issue that was brought up by Commissioner Garcia. Commissioner Garcia was basically proposing that we strike the language under the Roman numeral 1 until 1 year from the date of this resolution. I think that language was probably put in there at the direction of the town attorney, and I'm not sure.
No, sir. If I may, Mr. Chairman, this resolution was drafted by the county. Now, I've made some changes, not substantial changes, but this was drafted by the county. In the discussions that we've been having, there's been a lot of discussions, actually. And this is one of the things they asked us to do, and we're happy to do that. We think it's a good idea for all parties concerned.
And do we have, is there a legal basis to deny annexation when somebody has the right to petition?
No. If someone comes and petitions, right, we'd have to consider them. But I guess what we're signaling with this is that they are not going to get the most favorable, at least from the staff, they're not going to get favorable recommendations.
They would come to us first.
Yes.
Correct?
Yes.
And then they would have to be ratified by the council.
Well, that's a procedure we want to put in place, which is part of the work that we're going to have to put in place here.
Mr. James, can we pass a resolution that basically already puts out there what's going to happen if somebody makes that petition? We're basically saying we won't approve any petitions for annexation. And if we strike that language, it goes beyond until 1 year, and it says we will not approve any petitions for annexation until the town and the county approve a development plan for this corridor.
I guess the way my office looks at this is it is a form of a moratorium, which is acceptable for a defined period, generally better shorter than longer, because what you're talking about, as the town manager pointed out, is a right that's granted to people under a statute. So the moratorium concept is probably sustainable in this instance, where there is no defined plan for development, and as a result of that, it would make it very difficult for the town or this body or the town council to make a reasoned decision given the criteria that are available. So it's appropriate. It's appropriate for as short a time as we can make it. I hope that it doesn't last a year, quite frankly. My most recent experience with this has been in a community that refused to consider liquor license transfers for some period of time. That came to a very unhappy end for lack of a real rationale. But this particular form of moratorium, or it's not called that, but that's what it is, has an extraordinarily strong basis insofar as any annexations are not subject, as far as I'm aware. The county has no zoning whatsoever. We don't have zoning there. We don't have a plan. So I think it's sustainable, but again, shorter is better than longer.
Mr. Garcia, would you accept that rationale for leaving a term inside the resolution?
Well, as I mentioned, I do support this. I would support if it's not modified. I just have concerns, the history of the town and the county working together, that if it exceeds the year, and while people out there can submit for annexation, that it can really become a very difficult situation to make a decision on what the intent is for that area. And but that is the council and someone else to make that decision. I'm just looking at the planning and zoning position that we're at, and our direction of looking at the 2020 vision and trying to look at the town surroundings and see to make sure that we have a plan in place that makes sense for this community. So that's my concern. It sounds like the language there really doesn't have a real bearing. It's more of a situation to appease the county and indicate good faith. And so, if that's the case, I'll accept it that way with what I've heard. So,
Mr. Chairman?
Commissioner Dukes.
Just for clarity for us, what are the practical ramifications? Let's say somebody comes with an application to annex. Are they going to be turned away by the staff, saying, look, we have a moratorium for a year? Or are you going to take the application, and are we required then to turn it down or act on it as there was no moratorium? I mean, it creates kind of a strange
I would understand that if somebody makes the application, it's going to come to this Planning and Zoning Commission to either be approved, denied, or continued.
Yeah, but in the same breath, to say it's moratorium, and at the same time we're proceeding as if there was no moratorium. It's kind of a strange round for me.
Well, as our town attorney was explaining to us, I mean, the shorter is always better, precisely because of this. People have a right to petition. We have the obligation to give them some due process there. With this, though, we are announcing what our intended recommendation is going to be. Obviously, at any time, the council and you can go a different direction, and that'll carry the day, of course. What we're intending with this is just to give everybody certainty out there about, okay, you've worked on a plan out there. We want to stay with that plan, give more certainty to that plan, so that your neighbors, we don't start the sooner effect where people start to ask for annexation in order to get around it and then if one does it, then the other one will have to do it, and then before too long, you will be consumed and very distracted by the many number of petitions that could potentially come in a run like that. So we're trying to stave that off, and so I think that it is good public policy to tell everybody before they come in, this is what you're going to face if you come in like this, and it's not forever. It's for a time, and it's for a purpose, and that is so that we have a plan, so that when you can't come in, you know what you're going to come in for. You know the chances that you stand for getting approved or not.
Understood.
Thank you.
Commissioner Lee.
I have a few questions. Who drafted this for the county?
Rick Bellis.
Rick Bellis did? Okay. Now, I feel like, maybe I always feel like this, but I feel like I'm operating on half information at this point. Is it the intent of the county to cooperate with the town pursuant to the annexation, or is the county going to sue the town and try to stop the annexation? Do we know any of that information, what's going on at the county level?
No, we don't know any of that information. And I think if you read the papers a bit too much, you might be thinking that there's a lot more to the story than that. There is a lot of conversation going on this matter, particularly the annexation, et cetera, with the county. This came from them. We very much look forward to seeing their plan. We're going to work with that plan. I'll be telling you in the next item about how Mr. Bellis himself will be, in some regards, speaking for the town in regards to these sorts of things. So there's a lot more cooperation going on here, I think, than is popular to say.
Sure. And I think everybody in the situation is kind of talking out of both sides of their mouth, because I think ultimately everybody here wants the airport to go through. I think we all think it's good for the community. But that being said, I think people fall on different sides of the procedure. Where's the town on kind of deadline levels as to, now that it's annexed, theoretically you'd be collecting the GRT, and theoretically now you can put together a proposal to get the matching funds so that you can actually build the crosswind runway.
Right.
Where's the town in that kind of timeline right now that the annexation has taken place?
Well, we just recently met a very critical deadline, which was March the 30th. We had to get all of the paperwork, actually have the ordinance done and filed with the county, and then filed with the state Department of Tax and Revenue, all before the 30th, so that they could then begin the process to change their rosters and work with the merchants in the affected area, so that July 1, that property, the town's GRT rate is in effect. They only change it twice a year, July 1 and January 1. So we met the deadline for that to change. So that will happen in July. Now, we are still in a part of the challenge period, if you will. So between now and April the 12th, I suppose, April the 12th, the state law allows for a challenge if you've got some standing on the issue. And so, I guess at some point somebody could try and exercise their rights to challenge that. Now, from the standpoint of the state revenue, everything needed to be done for that thing to be changed has been done. And so should this thing go to court and take however long it goes until a court orders for it to be reversed, can that thing be changed? So I think at least at this point we're safe. Now, what triggers us having to actually put our cash in and have in place a solid financial plan is when the FAA says, show us the money, the construction is going to start at this time. That's uncertain at this point. It could happen in a matter of weeks. It could happen in a matter of months. And so right now I'm trying to put in place flexible financing such that we could meet that match whenever it comes. And at the very beginning, I'll tell you part of what that plan is to simply sequester some of our capital funds, the cash that we have right now, to at the very beginning, pony up the minimum that we have and maybe finance the rest, because at this point we don't know exactly how that looks.
Okay. Now, from one perspective, it looks like the string zoning for the purposes of our string annexation is almost an inevitability that these properties along the corridor will want to attach. But from another perspective, it could seem as if the town was doing it by design, that in fact the town wanted to expand, or the town wants to perhaps join with the county to form this kind of joint planning and zoning department. Or I guess my question in some kind of broad, weird way is this a purposeful move, or was this because of the inevitability of the annexation so that you could get the GRT? Do you understand what I'm saying? Like, was there a discussion amongst town councilors that this annexation was a method of growing the town, or a method of forcing the county into some kind of joint planning and zoning department, or was it inevitable?
I would say yes to everything all the scenarios that you described there. And maybe, if Mr. Chairman, with your permission, maybe I could just go ahead and just move on to the next item, because you've raised enough issues there that it gets us into that other discussion.
Well,
We have to
Before we move on, should we take
Right.
action on this
We
resolution? or
we would
should
like, with any changes you have, my intent here is to engage you in this very important planning policy decision. And there's no requirement that it comes to you, but my intent is that for all of these matters, that we start coming to you a lot more, so you're a lot more engaged, and so that the council has the benefit of your advice and your insight in planning issues that come up.
I think my 2 cents in regards to this is the town council approved the annexation. So barring some other hurdle, we're moving on with it. And it's very likely, or it's a high possibility, that we would see applications for annexation. And I don't think it's in anybody's interest, ours, individual property owners, the towns or the counties, to annex any property until there's times for the cards to fall where they may, and there's a plan either by the town or and jointly with the county for what to do with property and how to zone property between here and the airport if we ever do accept annexation. So I think this is a good resolution. I would support us passing it. And there are some unknowns, Commissioner Garcia. You know, we could choose to pass it for a month or 6 months or a year. I think it's going to take a year for all the cards to fall out and for us to get some kind of vision for what's going to happen out that way if the annexation proceeds or if it doesn't. So with that, I would encourage us to pass this resolution, and then we can move on to the other matters on the agenda. Rudy, we're in a, this was brought up under matters of staff.
Yes.
It is a resolution.
Yes.
Do we need to open it up to a public hearing in order to take action on a resolution? Or
No, Mr. Chairman, you do not.
we can go ahead and take a motion and pass this?
Your pleasure.
Okay. With that, I think I would entertain a motion to approve, deny, or continue this resolution.
I make a motion to approve the resolution 1302.
Support. Second.
We have a motion and a second. Rudy, let's go ahead and do a roll call vote.
Okay, thank you, Mr. Chairman. Chairman Patterson,
Yes.
Vice Chairman Lee,
Yes.
Commissioner Lukes,
Yes.
Commissioner Garcia,
Yes.
Commissioner Perez.
Yes.
Okay, thank you.
We have 5 votes in the affirmative. And I'll go ahead and sign this resolution and then return it for staff.
Okay, thank you, Mr. Chairman. And then, Mr. Chairman, under item 6B, training for commissioners, I am going to contact the New Mexico Municipal League to get one of their staff to come down and train both the Planning and Zoning Commission and the Historic Preservation Commission on on being commissioners, basically, on what your legal responsibilities are, what your powers and responsibilities are as a commission, and also to give you training on just basically different aspects of being a commissioner, the legal aspects, Robert's Rules of Orders, things of that nature. At this point, Mr. Chairman and Commissioners, what I am waiting for in order to schedule this training is it's my understanding that Mayor Cordova has some applicants for the 2 vacant positions on the commission right now, and he is reviewing those applications. And so what I'm waiting for at this point is for Mayor Cordova to make a decision on filling the 2 vacancies on your commission. And once he makes that decision, then I will go ahead and schedule that meeting through the Municipal League to provide this commission and the Historic Preservation Commission with some training that will help you be better commissioners and help the Historic Preservation Commission be better commissioners as well. So that's where that stands at this point, and I stand for any questions if you have any.
Thank you, Rudy.
Regarding this matter.
Yeah. Commissioner Lee, questions? No questions? Thank you for that update. More training is always good, and I think it's always good to realize the role we play and the responsibilities we have, and training helps us do that. With that, I think we can move on to agenda item 6C, which is joint powers agreement between Town of Taos Planning and Zoning and Taos County.
Mr. Chairman, Commissioners, what I want to do is just report to you what we're doing with the planning department, I guess. Specifically, the questions that Commissioner Leah asked. We are down to a very skeletal crew. A lot of people have left, and so what we're doing is instead of just automatically just filling those positions, is taking a close look at how we do business there, and is there a better, and also asking is there a better way to do business. And so what we're trying to do then is go to a model where there's a lot more coordination, a lot more collaboration with the county on planning issues. I don't know how long this idea has been around in the community, but I can tell you that this is an idea I pitched myself to Rick Bellis, even as he was considering going back to the county after his sojourn. And he thought it was a good idea. I later, about a week and a half later, 2 weeks later, I had a meeting with Mr. Bellis and the town and the county manager, Mr. Archuleta, where I again pitched the idea. And I said this would be a good thing for us to have in place precisely for issues like annexation. At that time, annexation was an issue that was starting to grow. It'd be great for all of us to have at least the same information and to discuss issues like that. This would be a good idea for that. At that time, the concern that, well, there'll be times when we'll disagree, and so whose master will that be? And the position that Mr. Bellis and I have always had is that, well, the data will be the same. You'll get the same data, and there shouldn't be anybody moving the data according to what the policy direction is. And so hopefully better policy will be made out of this. That idea did not move forward. The county at that time, as you recall, they were just there was a new commission coming in, and they were sort of getting set. At the same time, we had deadlines, including annexation and the joint powers agreement for the 911, et cetera. But those issues that you've heard about, high-profile issues, the council debated them, and well, a lot of what was covered, at least in the media, about how those discussions went. But at the same time, parallel to that, there have been discussions, at least among the individual council members and the individual commissioners. So there's still a very strong will on both sides, unanimously, I believe. I'm convinced unanimously for the two entities to work together, to keep trying to work together. And so even after that very high-profile, if you will, disagreement on policy regarding annexation, both sides have said this is still a good idea. Let's go forward with this idea. Let's try it. At this stage, I can tell you there are no details to it. It would happen via at this stage, via a contract for services agreement between us and the county. There would still be I'm still looking to replace Matt Foster's position. It'll probably be a position called an assistant planning director. And then we will be moving forward in the form of this service agreement. One of the things that, apart from just keeping things moving forward, just normal business rolling forward, the effort, the assignment to Rick Bellis, and which I've accepted also for myself, will be then to then define the ways that they're going to be able to work together and work together better, including putting things online so that people won't be affected by the change one way or the other, and so that and also streamlining things so that there's minimum discretion. There's a lot of certainty as to what you get. When you put your petition in or you put in your application, etc. And so what this effort then is an attempt to change the way we do business, go to a new business model. Since I got here, I have been hearing from at least all of the council members that we really do need to change the way we do business in planning. People aren't satisfied. We know we're burning the staff out as well, and just no one's happy with how it's going. I know I've heard from some of you as well your concerns about this, and so we're changing that. And so it looks a little rough right now, and that's the road to change. So with that, that's where we're at right now. Hopefully next month you'll have an introductory presentation by the town county planner, Rick Bellis.
At some point, would there be a collaboration of the town planning and zoning and the county planning and zoning to decide what the zoning will be in the annexed corridor?
Areas. At this stage, we don't know how that's going to go, but no question it's going to have to go to both bodies. Now, will it go to one, then the other, or maybe there could be a joint session or something like that? And then I think even the longer question, the longer term question is, well, then is that how we're going to function with two bodies? One inside the town limits, one outside the town limits. I promised Mr. Bellis is that all those issues were part of what had to be tackled. You're going to see them here. We're going to be sharing those decisions and all along the way, all the steps that we take with you, so that you know what all is happening. It is an ambitious undertaking. In the best of circumstances, this is a hard thing to do. And we're not starting out in the best of circumstances. We're starting out with two organizations that do business very differently, and we're trying to collaborate. And so this is a very positive thing, I think.
Do you feel comfortable with Mr. Bellis's qualifications? Because he'll be filling Matt Foster's large shoes.
Yes. I would say this about Mr. Bellis. I would not try this with anyone else. I trust his intelligence. I trust his integrity. I know we communicate well together. In the darkest times that you heard about, the talks between the county and the town, we always talked. I respect his judgment. I think we would be well served by him, and I just think you're going to see just good things come out of this eventually. It'll be frustrating. I mean, and I would encourage you, if you have questions, if you have concerns, raise them. We'll address them here. We will respond as much as possible with a roadmap of where we're going, the places we're going to stop along the way, where you're engaged, and all that sort of stuff.
The concept I think, is great, and just in that alone, that there's a communication between the county and the town, which is very refreshing. That hasn't happened in a long time.
Yeah. And it's happening because the commissioners want it, and the council members want it too. So,
Thank you.
Any other questions from commissioners? I'm really encouraged by it. I think it's a big fundamental change in the way that we've seen planning and zoning done for a long time in the town of Taos and Taos County. I think it's refreshing. I think it's the right thing to do in terms of the usefulness of staff and the efficiencies of both departments. And I'm really encouraged by it, and I'm really excited to see what comes out of it. So thank you for that. Let's see. So I think that finishes agenda item 6. With that, we can move on to agenda item 7A. I think we addressed that a little bit. We talked about commissioners and staff at planning and zoning.
I'm good, I guess.
With that, if we're good with agenda item 7A, we can move on to agenda item 7B that was brought up by Commissioner Luke's election of officers.
I'd like to preface what I'm going to say with the statement that what I'm going to say comes from a place where I have no ulterior motives. I would like to rescind the vote of electing officers of the commission for several reasons. One, 2 commissioners were absent, and another reason was the commissioner who made the motions was pretty much a lame duck who was departing the commission, and I think it was inappropriate for him to make those motions because, let's say, if it was a different subject that he was making motions on, it would have saddled the commission with something that the commission would be saddled for a year and I think, therefore, he should have abstained or not make the motions. And as a matter of fact, I don't think he should have even voted. And I think in selecting officers of the commission, there should be some rationale to it. And when Jim Thompson was the chairman for the commission, it appeared chairman for the commission for life. I thought the prudent thing for the commission would be to implement some mechanism where everybody gets a chance to be in the role of vice chair or chair, where, let's say, the vice chair ascends to the position of chair, and so there's some rotation, so everybody gets the experience of holding meetings and leading meetings. Another concept would be that the mayor appoints the chairman of the commission, and then the commissioners elect the vice chair. I think that the process has to be devoid of any outside influences where outside agendas infiltrate the doings of the commission, the actions of the commission, outside allegiances, outside whatever. And that's why I had a problem with the election of the officers of the commission as it took place the last time. Number one, 2 commissioners were not present. Number 3, it was a commissioner who was leaving the commission making the motions and nominations. So I'd like discussion on it, and where I'm going with it is I'd like to rescind, and tonight all the commissioners are present, so take another vote.
There's an item on the table for discussion. Is any other input from commissioners?
I think Commissioner Lukes makes good points. I mean, maybe for purposes of electing officers, that it'd probably be a good idea to have all of the commissioners at the meeting. I think that it should be brought up in a kind of a formal manner, and maybe perhaps addressed at the next meeting, where it's actually a motion on the table, and then we have a discussion about it, and then see how the commission feels.
And I think down the road also we ought to implement the process of electing officers into the commission's bylaws, because I think the bylaws are silent on the subject. So there should be some guidance in our bylaws how to go about it, instead of okay, you do it, oh, he does it, or like. And I know Commissioner Suazo nominated. Every motion he made was typically to nominate an officer. So I just like to bring some sensibility and some into the process. So that's all.
Mr. Perea, I'm pretty sure it is in the bylaws, and there are rules for when we elect commissioners and how we elect them. And
Mr. Chairman, yes, that is
remind us of
correct.
those?
Yes, Mr. Chairman, Commissioner Lukes, that is correct. In the bylaws, at the beginning of the calendar year.
Oh, I know that.
Elections
the timing
for
is covered. Sure.
Yeah, and then if I may make a suggestion, Commissioner Lukes and commissioners, you do have 2 vacancies on the commission at this point, so I don't know if you'd be willing to wait for those vacancies to be filled before you do this election, because or if you want to just proceed to have another election to elect a new vice chairman and a new chairman, that would be your call. But that's something to consider as well, is that you do have 2 vacancies, so at this point you would be basically depriving 2 commissioners of their rights to elect
At the
a
same
chairman.
time, the commissioners to be really don't know the current commissioners.
Yes.
So I don't think their vote would be. What would their vote be based on? That's my question.
Okay. Well, it's just a suggestion, Commissioner Lukes. If you, of course, you have that within the purview of your, in your rights to go ahead and hold another election, to do that. But I'm just suggesting, that it's just a suggestion that you might want to wait for the 2 commissioners to come on board and then hold your election. But again, you as a commission have the right to do it now, at the next meeting or.
I think the chairman also was asking, other than the timing of the election, we all know that. That's what the bylaws say. Do the bylaws address the procedure or what the basis for electing officers, or just the commission elects chairman and vice chair? I think that's all it says. It doesn't give any kind of meritorious suggestion how to approach it.
That's correct, Chairman Patterson, Commissioner Lukes. That's all it talks about, you know, in the bylaws, is that only those two positions are elected by the, you know, the commission. And again, you know, that's all it states in the bylaws. It doesn't say, well, you know, the vice chairman should have this much experience on the commission, that, you know, the chairman to be elected has this much experience. You know what I mean? In other words, there's no
Rationale, and that's
criteria, you know, to be used to even nominate, you know, a chairman and a vice chairman in the bylaws. All it says is you have to elect them. It doesn't say, you know, they have to have these certain qualifications before they can even be nominated, you know.
So the first thing that I would change in the bylaws is that the full commission has to be
Well, I think
present.
that's difficult to do. I think this has been a challenge because we have we have 2 vacancies, and it's been like that for several months now. Along with, we probably should have seen one member leaving office, and maybe that should have been addressed. Probably placed at our table till the other members were here. But saying that, I think it's still a majority. That's how it's selected, by the majority. If you feel very adamant about this, and sometimes you can't make it, but you should be here so that discussion can come out. But
Yes.
I think what happened was that, you know, 2 of us were gone and one was leaving. All of a sudden, you really don't have a real core of the commission making that decision.
Yes.
Just to make another comment, I believe, and I agree with Mr. Pereira, is we should, if we're going to look at this again, we should allow the other seats to be filled and then have a discussion and election then. You know, I think there was no ill feel here or intent to do something. I don't believe that. I think we work well together. I think there's an array of experience and knowledge here. It's just the way it took place, and it was all driven by a lack of having a complete commission here. And so forth.
Mr. Chairman, if I could interrupt, this is an interesting discussion that should probably be held when this is a regular agenda item. And I would also point out that bylaws being bylaws, there's also an ordinance section that provides for an election of the chair and vice chair at the first regular commission meeting in each year. The ordinance also provides that a quorum is necessary to conduct votes, and there's nothing in the ordinance about motions for reconsideration. Typically, those are done at the subsequent meeting by a member who voted with the prevailing side. So there are some, there's an ordinance, so which trumps the bylaws. So if the commission wants to take this up, it's certainly appropriate. Certainly the town attorney's office is happy with whoever you elect as commissioner. It doesn't matter. But there is an ordinance in place. This should be an agenda item. And if you're going to make changes, you should think about this in terms of the ordinance that exists. And you guys don't change ordinances. The town council does that. So you need to be aware of that as well. So I would ask that the discussion continue when this is a regular agenda item, because it could be that there are lots of people in the public that would like to weigh on this as well.
So with that, I think if it's the pleasure of the commission, I think we could choose to add it as an agenda item in our next meeting. I don't think Commissioner Suazo was with us for a long time. He was with us, I think, more than 3 or 4 years. I don't believe there was any agenda behind Commissioner Suazo making recommendations or the elections we had. The elections we had were made with a quorum. Everybody on the commission knows that elections are taking place in the first meeting of the year. My suggestion is that if we feel really strongly about that we show up and we attend the first meeting of the year when the elections are made. I'm open to whatever the commission feels is most prudent. If we choose to take some action and move forward with this, I think that's fine. Let's add it as an agenda item at our next meeting and continue our discussion then. So, election of officers and Commissioner Lee, I believe you requested that we bring up item number 7C, which was future commissioners. I think we've covered that as well.
I did not.
Did not?
Excuse me,
Did somebody else?
Commissioner Patterson,
Was that?
according to Mr. James, we can't have re-elections because of the ordinance. We are bound by what we agreed on. Unless an ordinance is changed, we've already done this election and it's final.
That's correct. So we could bring it up at another commission meeting, and if we'd like, we would have to propose and pass an ordinance to change that and have a new election.
Right.
Yeah. So I think Mr. James is saying that we probably shouldn't discuss it any further. If we are going to discuss it further, we should make it an agenda item for the next meeting. Yeah. Okay. And somebody brought up agenda number 7C, which was future commissioners. Was that?
That was not me, unless I have.
Okay. Yep. Okay. So with that, I think we've covered the agenda. Are there any further matters from commissioners? With none, we can move on to agenda item number 8, which is adjournment.
So moved.
Move in a second. All in favor, say aye.
Aye.
Adjourned.
Okay, thank you, Mr. Chairman. Thank you, commissioners.
You do?